All right, welcome to the Explainer. Go ahead and get those notebooks ready, clear away the distractions, and let's settle in. Today, we're running a highly structured exam review session, and we are going to unpack one of the absolute foundational pillars of Indian contract law. I'm talking about the 1882 landmark case of Chinnaya v. Ramayya. Whether you're prepping for a final exam, maybe studying for the bar, or honestly just kind of fascinated by how legal systems unravel complex human drama, well, you're exactly in the right place.
Okay, so let's dive right into this with a classic law school hypothetical. Picture this. An aunt sues her niece, trying to force her to make a promised payment. But here's the catch, and it's a big one. The aunt literally gave the niece nothing in return for that promise. I mean, not a dime, not a service, absolutely nothing. Now, if you know your way around basic contract law, your spider sense is probably tingling right now, right? Because a contract usually requires a two-way street of value. So, can she actually sue? Just test your intuition for a second. Got your answer? Okay, good. Let's see how the law actually handles this. To get a perfect grip on this case, here's our review session syllabus. We're going to use the highly effective FRYRAC method, marching straight through the facts, issues, rules, application, and conclusion. Let's jump in. Starting off with part 1, the facts. Exactly how did this whole dispute arise? Let's walk through this timeline together. The story kicks off with an elderly woman, a mother, who owns a piece of property. Step 1. She decides to transfer this property to her daughter, Ramayya, through a deed of gift. But it's not exactly a free and clear gift. The mother attaches a very specific string to it. She basically says, Ramayya, you get the property, but you must pay an annual maintenance allowance to my sister, your Aunt Chinnaya. Okay, moving to step 2. Ramayya accepts the property and voluntarily signs a separate, legally binding agreement, promising her Aunt Chinnaya that she'll make those annual payments. At this point, everyone's happy, and for a while the payments actually happen, but then we hit step 3. Ramayya just decides to stop paying. And that triggers step 4. Aunt Chinnaya, suddenly cut off, marches straight into court and files a lawsuit to enforce that written agreement. Which brings us to part 2 of our FRYRAC review, the issues. What was the core legal battle here? So the Madras High Court had to answer this absolutely critical question. Can a person who provided zero consideration actually enforce a contract? Now, as we know in contract law, consideration is really just a fancy word for something of value given in exchange for a promise. Chinnaya, the aunt, was trying to enforce this promise made by Ramayya. But Chinnaya herself had given Ramayya absolutely nothing in return. All the value, the actual property, came from the mother. So without providing any consideration herself, did Chinnaya even have the right to stand in a courtroom and demand that money? This perfectly mirrors the exact tension you'll need to dissect on your law exams. On one side, the plaintiff, Chinnaya, argues, look, Ramayya got a whole estate. The mother's transfer of that property was a consideration for the promise. Ramayya accepted the condition, so boom, she's legally bound. But the defendant, Ramayya, fires back with a really technical, traditional contract law argument. She's saying, wait a minute, I have an agreement with Chinnaya, but Chinnaya gave me zero consideration. And since my aunt didn't give me anything, this agreement between her and me isn't a legally binding contract. Honestly, it's a pretty brilliant defense. So who's right? Grab your highlighters, folks, because we're moving on to part 3, the rules. This right here is the text you need to memorize. According to Section 2D of the Indian Contract Act of 1872, an act or promise becomes consideration when it's done at the desire of the promiser. And crucially, pay attention here, that consideration may move from the promisee or any other person. And this brilliantly illustrates why actually looking at the primary source text is so vital for exam prep. Notice it doesn't say the consideration must come from the person receiving the promise. It explicitly says, or any other person. To really cement this in your mind, let's look at the fundamental contrast between English and Indian law on this issue. If this case had been tried under strict, traditional English contract law, Ramayya probably would have won. English law generally dictates that consideration must move directly from the promisee, which in this case would be the aunt. But Indian contract law was intentionally drafted differently. It takes a much broader approach. It specifically allows consideration to move from the promisee or any other person, meaning a third party. All right, let's move to part 4, application. Let's see exactly how the court applied this rule to our facts. So the Madras High Court took that rule from Section 2D and applied it directly to our timeline. They observed that Ramayya made a promise to pay Chinnaya. Okay, did Ramayya get consideration for that promise? Yes, she got a piece of property. Did that consideration come from Chinnaya? No, it came from the mother, a third party. But did that matter? Not under Indian law. Because Ramayya desired the property and the mother provided it, that transfer was deemed entirely sufficient consideration to support the promise to the aunt. The legal loop was closed, even though the aunt hadn't contributed a single thing herself. And finally, that brings us to step 5 of our fire rack review, the conclusion. Let's look at the final verdict and build your ultimate cheat sheet.
The Madras High Court ruled firmly in favor of the plaintiff, Chinnaya. Ramayya was legally bound to honor her agreement. Because valid consideration existed in the overall transaction, she couldn't just take the property and then dodge the attached condition simply because the consideration came from her mother instead of her aunt. No way.
Now, if you see Chinnaya v. Ramayya pop up on your exam, these are the 4 key bullet points you absolutely must hit. First, the transfer of property equaled valid consideration. Second, and this is the big one, third-party consideration is completely valid in India. Third, always remember the caveat. That consideration must still be given at the promiser's desire. And fourth, the ultimate legal principle established here is that the validity of consideration does not depend on who actually provides it.
You know, this 1882 ruling is really a masterpiece of legal flexibility. It recognizes the reality of how families and businesses actually structure their deals. But I want to leave you with this final thought to ponder. Does the inclusion of third-party consideration make Indian contract law fairer by enforcing what people actually intended? Or does it make it more complicated by allowing people who gave literally nothing to drag others into court? Think about that as you review your notes. Thanks for joining me on this deep dive, and I'll see you on the next explainer.